Welcome to this explainer. Okay, if you're a law student, you totally know that heavy, pit-in-your-stomach feeling of stepping into a courtroom for the very first time. Well, today, our goal is to literally transform you from an anxious student into an absolute courtroom hero. We're demystifying the ultimate test of legal education, the moot court.
So, here's the game plan for today. We're going to cover what a moot court actually is, why mooting matters so much, the whole preparation process, courtroom etiquette, and finally, how to absolutely master those oral pleadings.
All right, Section 1. What is a moot court? Let's talk about stepping into this environment and really embracing the drama and formality of the legal world. Now, what's really interesting here is the mindset shift. You are not just a student reading from a textbook anymore. No way. In a moot court, you're a professional. You're acting as legal counsel, representing either a plaintiff or a defendant in a highly detailed mock scenario. And you're arguing these incredibly complex, debatable questions of law right to a judge's face.
But let's set some boundaries here, because it is definitely not like a TV crime drama. Mooting focuses purely on the legal arguments of an appeal. So that means no juries, no live witnesses crying on the stand, no surprise evidence reveals, and, no legally binding outcomes. It's a completely controlled environment dedicated entirely to applying the law.
So picture the room with me. It's a really intimate setup. You're staring down the judge, or maybe even a whole bench of judges. Right in front of you is the moot proposition. That's your fictional legal problem. Sitting at the tables are the counsels, which is usually 2 speakers and 1 researcher for each side. And then you've got the court clerks who are just there to help run the whole session smoothly.
Moving on to Section 2. Why mooting matters. Why on earth would you willingly subject yourself to this level of stress and scrutiny? Well, the truth is, mooting unlocks these core benefits that you literally cannot get from just burying your head in a textbook. It forces you to build incredible public speaking confidence. It drastically levels up your deep research and writing skills. Plus, it teaches you how to function in a really high-stress team environment and gives you a massive global networking platform to connect with peers and actual legal professionals.
But here is why this is absolutely crucial for your future: the career impact. Look, law firm recruiters actively hunt for mooting experience on a resume. It's a huge green flag. It proves you've got discipline, real practical courtroom knowledge, and the ability to think critically on your feet. Basically, it shows employers they're investing in someone who already knows exactly how to act like a lawyer.
Okay, Section 3, the preparation process. Now that we know why we do it, let's switch into training mode and walk through exactly how to prep before you ever see the judge.
As you'll see, it is a very strict step-by-step workflow. First, you get your case and you dive deep. You research the law heavily. Second, you write out your skeleton argument. Third, you prepare your trial bundle. And only after all that prep work is done, step 4, do you actually step up to present your oral argument.
Let's demystify a couple of those jargon terms real quick. Your skeleton argument is exactly what it sounds like, actually. It's a shared, written outline of the bare bones of your case so the judges and the opposing counsel know exactly what you're going to argue. And the trial bundle? That's your master document collection. A massive pro tip here: use clear tabs and highlight the significant text in your bundle. It seriously helps the judge navigate your documents without missing a beat during the heat of the trial.
Right, Section 4, courtroom etiquette and manners. Because all that brilliant preparation, it won't save you if you bomb the unspoken rules. Courtrooms have these highly specific, completely unbending rules. For the do's, you absolutely must bow when entering or leaving the room, make sure the appellant sits on the left and the respondent sits on the right, and always maintain solid eye contact. But the don'ts? Oh boy. Don't wave your pen around while you're talking. It is super disrespectful. Don't shift nervously from foot to foot. Never ever turn your back to the bench. And, this is a big one, absolutely never interrupt a judge. The crucial takeaway here is showing absolute, unwavering respect to the bench at all times. You've got to address the judges properly, with titles like Your Honor, Your Excellency, or Your Lordship. Actually, a fantastic piece of advice is to ask beforehand how a mixed panel of male and female judges prefers to be addressed collectively. That way, you aren't awkwardly stumbling over your words in the heat of the moment. So, what do you do when you desperately need to talk to your team while your co-counsel is speaking? Well, you cannot whisper. No way. Instead, use sticky notes to communicate discreetly, or silently pass materials through the court clerk. It keeps the whole flow of the court completely undisrupted.
And finally, Section 5, mastering oral pleadings. This is it. You're stepping into the shoes of the counsel,
for the ultimate test.
When you finally step up to that podium, you don't just say, "Hey, I'm here for the defendant." Nope. You must wholeheartedly memorize this exact phrase. "May it please the court, my name is blank, and I appear on behalf of blank." This highly stylized opening sets that professional tone literally from second one.
Once you actually start, remember this absolutely fundamental rule. Treat your oral arguments as a moderate, steady conversation with the panel. It is definitely not a narrated speech where you just stare down and read off a paper. You need to actively listen to the judge, take a slight pause to mentally formulate your answers, and always prioritize the judge's lead. Even if they completely derail your carefully planned argument, you follow their lead. Your vocabulary needs a major upgrade here, too. You have to swap out subjective, everyday language for purely objective phrasing. So get rid of casual phrases like "I think" or "I feel." Instead, use formal statements like "it is our submission" or "the counsel acknowledges," and definitely avoid confrontational words like "we argue." You want to stay completely professional and detached.
But what happens if the judge absolutely corners you with a question you just don't know the answer to? Never bluff. Seriously, never lie. Your ultimate fallback phrase is simply, "the counsel pleads ignorance." You can then politely ask for a chance to make a calculated estimate, but be warned, use this only as an absolute last resort.
Wrapping things up gracefully is just as important as your grand opening. If your time is up, you politely ask, "May I briefly conclude?" End your whole argument by stating, "That concludes my submission," and then ask if you can be of any further assistance to the court. Say thank you, and remember, when the session is completely over, you stand and you wait for the judges to leave the room first before you even think about exiting. We have covered a tremendous amount of ground in this explainer today, so I want to leave you with this one final thought. If a moot court is really just a fictional trial with no real-world consequences, how will mastering its artificial rules shape the very real future of our justice system? Because honestly, the students practicing these fictional cases today, they are the real-world legal powerhouses of tomorrow. Mastering these steps doesn't just help you pass a class, it literally builds a career. Thanks so much for joining me, and I really hope this guide helps you absolutely crush your next moot court.